Well, good morning. It's a pleasure to be here, and I think from the introduction you worked out that I am a patent attorney, and that's what I want to talk to you about today. I guess what a patent attorney is, what they do, and how they fit into the pathway to commercialising medical research. So, what is a patent attorney? Well, despite the appearance and the name, we're not actually lawyers. Some of them have law degrees, but not many, and you don't need a law degree to become a patent attorney or register as a patent attorney. What you do need, though, is a technical background. So what you'll find is that all patent attorneys must have a technical background, and so you'll see they're either scientists or engineers, and they usually specialise in their particular areas of science, and they're the technologies that they concentrate on in their practice. So what do patent attorneys actually do? Well, what they do is protect other people's ideas. So in my day-to-day work, I get to see a lot of ideas. It's probably one of the best parts of my job, and I really enjoy it. Get to see some pretty big ideas like we've seen today, some small ideas and some really amazing ideas, and to be honest, from time to time, some pretty ordinary ideas. But what we try to do is have a look at those ideas and provide advice on how we can try and protect them. And typically, that's about trying to transform that idea into a piece of intellectual property. So why would you want to transform an idea into a piece of intellectual property? Well, once it becomes a property right, and when we're talking about medical research, generally we're talking about a patent right, then that idea is provided with a set of qualities that make it quite exciting. What we're able to do is potentially now sell that idea. We can perhaps license that idea, or we can potentially control how we can use that idea and get a monopoly over that idea. So if we're in the business of commercialising the product or an idea from medical research and we transform that idea into an intellectual property right, then all of a sudden that idea becomes very attractive to the investment community, because what they see is that potentially you can get a competitive advantage in relation to that idea and potentially control how that's used. But it's not just investors that get starry-eyed over intellectual property rights. You'll also see that the other great source of funding, and it was mentioned in the previous talk, government funding. If anyone's been down the pathway of applying for a grant through government funding, you'll see that a great emphasis is also placed on making sure that any ideas that come out of medical research are properly protected through intellectual property rights. Now, it's fair to say Australia doesn't have the best track record when it comes to commercialising ideas, but in the area of medical research, we have some fantastic examples of some successful enterprises. So one that you'll all be very familiar with is Cochlear, founded in 1981, I think. And at the time, it was a government grant was sought on when they developed that or created that company, and it was all about commercialising the bionic ear that was developed by Dr. David Clark at that time. Another example, ResMed. Again, a local Australian company developed the CPAP technology for treatment of sleep disorders. And CSL, another fantastic example of a leading Australian entity, derived out of the Commonwealth Serum Laboratories and privatised in the 90s, but they're now world leaders in blood plasma products, vaccines and anti-venom products. But what you have in common with each of these three examples is they all came about through commercialising ideas that came out of medical research. Those ideas, in each case, were properly transformed into IP rights, which gave each one of those entities a real competitive advantage in their particular field. And you see that they took great advantage of that competitive advantage. I guess what's interesting, though, with those three examples is they've all been around now for a good 20, 30 years, and they're still right at the peak of their field. And what they've done during that time is actually still maintain a huge investment in research and development. That research and development generates more ideas, and they have a real constant program of making sure those ideas are also properly protected and transformed into IP rights and maintaining that competitive advantage, which gives them their standing today. So we've talked a bit about making sure we can transform our ideas into potentially intellectual property rights. But when's the best time to do this? Well, this often depends on a number of factors, and generally the pathway to commercialisation for individual technologies is quite specific and very different depending on what areas you're working with. And so this can really control at what stage you might investigate turning your ideas into IP rights. But one very important and fundamental factor is it's always important to investigate this before there's any public disclosure of your idea. So in essence, make sure there's no publication in scientific journals and no public disclosure of your idea before you at least investigate whether you're able to get some intellectual property rights for that idea. Now, I've probably spruiked IP rights enough over that little section, but I really do want to emphasise that they are certainly not the be-all and end-all to commercialising technology, and there's many examples of companies that have been very successful in commercialising technology without necessarily going down the patent pathway. In fact, much of my practice is talking to clients about, perhaps IP rights or patent protection in particular is not the most appropriate form of protection that you can go for. Another Australian example, another successful example, not in the area of medical research, is Atlassian. Now, I remember talking to these guys very early on in the piece, and they were founded in 2002. Now, they said to me, look, we just don't believe in patents. They didn't use that strategy at all. They certainly developed some great ideas. They had a wonderful software platform that allowed collaboration amongst a number of different people through an organisation. But what they did was develop an innovative web platform where they could distribute that technology to a huge customer base right around the world. And that really kick-started their business in the early days. But you see, it's not the be-all and end-all. There's a number of factors. Is IP protection the right thing for you? When is the best time to do it? A lot of things to consider. And the best way to try and navigate through that particular area is to get some really good advice and nice and early on. And a good way to do that is to come and see a patent attorney. And as I mentioned, we do like to hear about ideas. Thanks very much.